Okay, so this is part 3 of the August 19th hearing with Yehuda Ferris of Chabad of the East Bay as trustee and his attorney William John Rogers, who made Yehuda Ferris a beneficiary in the trust. Also, he made himself get paid in the trust, Will Rogers. And this is a transcript of a hearing from August 19th. This is part 3 in a series of videos. So the court, which is a judge, it's hard to see here, it says, it's really difficult to see, hold on, says, why don't you just stay where you are? And Madam Clerk, do you want to swear Mr. Rogers in? He's the one that wrote the trust that were never honored. So then, so William Rogers, having first been duly sworn, testifies as follows. The clerk, please be seated and state your name. William J. Rogers. All right, Mr. Rogers, you probably haven't testified very many times before, but you're probably questioned witnesses. The court, if there's any witnesses in the courtroom, okay. If you're a party, you can certainly stay. Mr. Markley's procedural question. When they're finished and the questioning is done, may I question at this time or is it another time? May you what? Mr. Markley's question Rogers. Is that another time? Because I have questions for him. You can question him within the scope of the questions that are asked on direct. Okay, so is there ever a time in the trial when I'll be able to ask him questions? Again, you can question him about the things that he's asked about in direct. You can't ask him about anything else at this time. Mr. Margulies, at this time, okay, so someday? The court, all right, and so, as I was saying, Mr. Rogers, just listen to the questions. There we go. Just listen to the questions, make sure you understand it, and if you don't, let the attorney know or whoever is asking, and they'll, I'm sure, do their best to clarify. Direct examination by Mr. Horn. Now they're buddies, they're allies, they work together. He's, Mr. Rogers and Trustee who's sitting here, he sold $1 million worth of real estate of a dead cancer patient whose trust this is to Horn's clients, the two daughters, in total violation of the trust. Okay, so now they're talking to each other. These are like, best of friends. Mr. Rogers, can you please introduce yourself to the court? Yes, I'm William Rogers, and William Rogers, and are you a licensed attorney? Yes, since 1991. Holy Toledo, senile. And, I'm going to get sued for slander. And you can please explain to the court your involvement, if any, in the administration of the Lee J. Ziplin Trust. Yes, I'm the attorney for Rabbi, he's not a rabbi. Where's his ordination? You seen any ordination papers? Just call him Joe. Rabbis like the name Joe. I'm the attorney for Rabbi Yehuda Ferris, who is the trustee. Whoa, look out. And did you serve notification of trustee on the beneficiaries of Lee Ziplin? I mailed notice of administration, Mr. Horn. Will the record reflect that I am handing the witness a document marked as exhibit number 71? The judge, all right, the record will so reflect. By Mr. Horn, do you recognize this document? I do. And what is it? It is the notification by trustees pursuant to... Hold on, ladies and gentlemen. California Probate Code Section 16061.7. And is this a true and correct copy of the document? Yes, it is. Mr. Horn, Your Honor, I ask that the document marked Exhibit 7 be admitted into evidence. Any objection? Mr. Margulies, no. The judge, all right, this is a notification of trustee pursuant to Probate Code Section 16061.7. Gospel number marked as Exhibit 71 is admitted into evidence. Petitioner's exhibit admitted into evidence by Mr. Horn. Mr. Rogers, is that your signature on page 2 of the document? It is my signature. Hey, I got $57,000. I bet I'll sign for that. I don't care if the 3 poor siblings of the cancer patient, they got $4,000. Well, too bad. I got my $57,000. And can you describe what the second and third pages of the document are? The second page is the proof of service. The third page was entitled in my own handwriting, Schedule 1 to Proof of Service, and the address that it was mailed to. After you mailed the notification to Mr. Margulies, did anything occur that would lead you to believe that he received the notice? Nothing contrary would lead me to believe that he did not receive the notice. The notice was not returned in the United States mail marked undelivered, so I assumed that it was delivered. Hold on, folks. Okay, thank you. And was a notification by Trustee Exhibit 7 in the case the only notification that you served on the trust beneficiaries? At the time, it was the first notification given to the beneficiaries. And did any person file any trust contest or claim against the trust within the 120 days? No. And are you aware of anyone contesting the trust after 100 days? Yes. And who contested the trust? Noam Ziprin, also known as Noam Margulies. Oh my God, that evil guy. And do you know the approximate date he first contested the trust? I don't, but I know it was very close to 2 years after my calculation of the running of the statute of limitations. They never told us about the amended trust. Oh, that's okay. Would looking at the first page of Mr. Margulies' petition to contest the trust refresh your memory? Probably. Mr. Horn, will the record reflect that I'm handing the document to the witness? All right, said the judge. The record will so reflect. So, Mr. Horn, and do you recall on what date Mr. Margulies first filed an action seeking to invalidate the trust? Okay, hold on, ladies and gentlemen. It's just the beginning here. Okay. Well, this petition to contest the trust I see as a court stamp on it of July 19th, 2022, which was 2 years after 120 days, I served notice of what's happening to the light. Oh, God. The camera is messing up here. Okay, 1 second, ladies and gentlemen. Oh, God. I don't know what. Okay, let's go to. I'm going to stop this and start all over.